Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine dedicating years, maybe billions of dollars, all that brain power, to finding a cure for something really serious. And you find a way, right? A truly revolutionary method. But then, should your patent cover every possible variation of that cure? Even the ones you haven't figured out how to make yet? That, right there, is the huge question at the heart of Amgen Inc. et al. v. Sanofi et al. It's a fascinating Supreme Court decision that basically reaffirmed a really old, really crucial patent idea. If you claim big, you got to teach big. Welcome to the deep dive. We take complex stuff, cut through the jargon, and pull out what you really need to know. Today, we're diving into this landmark Supreme Court case. It's number 21757, decided pretty recently, May 18, 2023. Justice Gorsuch delivered the opinion, and it was unanimous, interestingly. Amgen and its partners were the petitioners, going up against Sanofi and their side, the respondents. Our mission, to really get our heads around this decision, figure out what it means for companies like Amgen and Sanofi, and honestly, what it means for anyone curious about how big ideas actually get protected by patents.
Yeah, this deep dive is going to show you how a legal rule that sounds kind of simple, this enablement requirement, how it actually shapes innovation in a huge way, especially in really complicated fields like antibody drugs. We'll basically explore why claiming way too much without teaching enough can, well, sink your patent. It's really about striking that balance.
Okay, let's unpack this. Before we even get to the lawyers and the courtroom arguments, we need to understand the science here. It's pretty incredible stuff. We're talking about fighting bad cholesterol, right? LDL cholesterol. We all know it's linked to heart disease, serious cardiovascular issues. But how do you actually fight it using engineered biology?
It's a massive challenge, absolutely. I mean, your body's immune system is already amazing. It makes antibodies naturally. Some scientists figure there could be as many different antibodies as stars in the galaxy, maybe a quintillion. And they're not just numerous, they're incredibly diverse. Structure, function. Their job is basically to grab onto antigens, things like viruses or bacteria, and neutralize them, like tiny guided missiles.
Okay, so in this case, the scientists weren't targeting a virus. They figured out how to engineer these antibodies to target something.
Well,
Our own bodies make a protein called PCSK9. What's the deal with PCSK9? Why go after it?
right, that's the key. PCSK9, it turns out, does something unhelpful. It finds LDL receptors. Those are the things on our cells that pull bad cholesterol out of the blood, and it destroys them. So if PCSK9 is taking up the garbage collectors, more bad cholesterol hangs around. The big idea was, if you can block PCSK9, stop it from destroying those receptors, you could help lower bad cholesterol. And researchers, including both Amgen and Sanofi, they zeroed in on this specific 15 amino acid sweet spot on the PCSK9 protein. Think of it like a very specific keyhole. Block that keyhole and you potentially disarm PCSK9.
Got it. So they found the target, this keyhole. What happened next? It sounds like a race was on. Amgen and Sanofi were both involved.
Oh, absolutely. The mid-2000s were buzzing with this research. Both companies actually succeeded. They developed their own drugs that inhibit PCSK9. Amgen came up with Repatha, Sanofi with Proluent. Each drug used a different unique antibody defined by its exact amino acid sequence. And both companies got patents for those specific antibodies around 2011. These were big deals, huge advancements.
Okay, but those weren't the patents that ended up at the Supreme Court. So this is where the story takes a twist, right?
Yeah.
In 2014, Amgen got 2 more patents, the 165 and 741 patents. What were they claiming this time? It wasn't just their specific antibody.
No, they went much, much broader. Instead of patenting just their specific key, Repatha, Amgen tried to claim, and this is the term they used, the entire genus of antibodies that could do 2 things. 1, bind to certain spots on that PCSK9 sweet spot, and 2, actually block PCSK9 from hooking up with the LDL receptors. So think about it. They're trying to claim the whole family of keys that might fit that lock and do the job, even if they hadn't actually made or even imagined most of them.
The entire genus is, wow, that sounds incredibly ambitious. So how many antibodies did Amgen actually describe in the patent? The ones they knew worked?
That's a crucial point. In their patent, Amgen laid out the specific amino acid sequences for just 26 antibodies that did these two things. 26. But the claim, the genus they wanted to patent, potentially covered millions of other possible antibodies they hadn't made or described. The difference in scale is just enormous. A handful of examples versus a potential universe of solutions.
So, okay, they claim millions, but only describe 26. How did they say others could make all those other millions of antibodies? What was the instruction? They are the roadmap and conservative substitution, right?
Exactly. Those were the two methods they proposed. The roadmap was, well, basically a multi-step process of trial and error. You'd have to generate new antibodies, test if they bind to PCSK9, then test if they bind to the right spot, and then test if they actually block the interaction, like a series of filters. Conservative substitution was about taking antibodies you already knew worked, tweaking their amino acid sequences slightly, and then testing those to see if they still functioned.
And what's the catch? Why isn't that straightforward, especially with antibodies?
The catch is biology's complexity, and this came up again and again in court. Changing even one single amino acid in an antibody can completely change its shape and how it works. And it's often unpredictable how it will change. Amgen's own expert even said something like, "We don't fully understand how sequence translates to 3D structure yet. Whoever figures that out gets a Nobel Prize." It's not like following a simple recipe. That lack of predictability, that's really central here. It's not just tweaking. It can be like starting over.
Okay, so Amgen gets these broad patents. Then they sue Sanofi, saying Sanofi's drug, Proluent, infringes on these super broad claims. What was Sanofi's main defense?
Sanofi hit back hard on that very point. They basically said, hold on, Amgen's broad claims aren't valid because Amgen didn't actually teach anyone how to make and use all the antibodies they claimed. Their argument was that the patent failed the enablement requirement of the law.
Right, enablement. Let's drill down on that. For those of us not steeped in patent law, what exactly is enablement and why is it such a big deal?
It's really the core of the whole patent system, the fundamental bargain. The law, 35 U.S.C. Section 12A, says an inventor has to describe their invention in such full, clear, concise, and exact terms as to enable any person skilled in the art to make and use it. This idea goes way back to 1790. The deal is, society gives you, the inventor, a temporary monopoly, like 20 years of protection from competition. But in return, quid pro quo, you have to fully disclose how your invention works so that when the patent expires, the public actually gets the benefit. They need to be able to make it and use it themselves. If the instructions are vague or incomplete, it's like, as Justice Marshall said ages ago, defrauding the public. The public needs to get its side of the bargain.
Okay, so Amgen, being the plaintiff, needed to convince the courts that their roadmap and conservative substitution methods were enough, that they did enable skilled scientists to make all those millions of antibodies. What were their key arguments?
They basically made three main points. First, yes, those methods are sufficient enablement. A skilled scientist could follow them and find other working antibodies, even if it takes some effort. Second, they argued the lower courts got it wrong, that they applied some kind of unfairly high standard just because it was a genus claim defined by function. They felt the Federal Circuit was demanding too much proof. And third, they raised a big warning flag. They said, look, if you rule against us, you're going to kill incentives for major breakthroughs, especially in unpredictable fields like biotech, where the upfront investment is massive and you need broad protection early on.
Makes sense from their perspective. But Sanofi and the lower courts agreed with them, had a different take.
Yeah.
What was their counter?
Sanofi, as the defendant, basically called those methods little more than a trial and error process of discovery. Or, even more bluntly, research assignments. They argued Amgen was trying to patent a research plan, not a fully enabled invention. They said Amgen was claiming potentially millions of antibodies, but hadn't provided a reliable way to actually find them without extensive inventive work. That's where the term hunting license came from. Sanofi said Amgen gave people a license to hunt for antibodies, not a map showing where they are. It covered a vast number beyond the 26 examples, requiring way too much guesswork.
So the case goes through the district court, then the Federal Circuit Court of Appeals, both sides with Sanofi, then it lands at the Supreme Court. What did they decide?
They decided unanimously to affirm the lower courts. They agreed with Federal Circuit. The bottom line was that Amgen failed the enablement test. They hadn't enabled others to make and use the full scope of what they claimed in those patents. The judgment against Amgen stood.
And the reasoning? How did the Supreme Court justify this? Was it just about the sheer number of potential antibodies?
It wasn't just the number, though that was part of it. The court's reasoning was really grounded in long-standing precedent. They basically doubled down on that core principle. The more one claims, the more one must enable. Simple as that, really. Amgen's claims were just too broad for the level of teaching they provided. They wanted a monopoly over a whole class of antibodies defined by what they do, but they didn't provide enough instruction for someone else to reliably make the whole class. The court saw that while Amgen obviously knew how to make their 26 examples, the claims went way beyond that, into uncharted territory that required, well, more invention.
And you mentioned precedent. The court didn't see this as some radical new idea, did they? They connected it back to older cases.
Oh, absolutely. They leaned heavily on classic patent cases, like O'Reilly v. Morse from way back in 1854. Samuel Morse, he invented a telegraph, right? An amazing invention. But he tried to claim all possible ways of using electromagnetism to send messages over distances, even methods nobody had thought of yet. The court back then said, nope, you taught us your method, but you didn't teach us every possible method. Amgen, the court suggested, fell into a similar trap, claiming a result without teaching all the ways to achieve it.
Any other key cases they mentioned?
Yeah, another big one was the incandescent lamp patent case from 1895. Some inventors claimed using any fibrous or textile material for the filament in a light bulb. But really, only carbonized paper worked reliably from their teaching. It took Thomas Edison doing his own painstaking experimentation, as the court called it, to figure out bamboo worked much better. Again, the court said you can't claim all materials if you've only shown how to use one effectively and left others to figure out the rest. Amgen's roadmap, the court felt, similarly required that kind of painstaking experimentation, that elaborate experimentation mentioned in another case, Holland Furniture. It wasn't just routine work.
So the analogy the court used was pretty striking, right? About claiming a kingdom but only mapping a small part of it, or the lock combination.
Exactly. They said Amgen tried to claim sovereignty over an entire kingdom, but only enabled a small part. And the lock analogy was very clear. It's like claiming all winning combinations on a huge 100-tumbler lock, giving 26 examples, and then telling everyone else, okay, now you just randomly try combinations until you find the others. That's not teaching, that's setting a research task.
So that roadmap wasn't enough. It was a hunting license. But isn't some experimentation allowed in patent law?
Yes, and the court acknowledged that. Some reasonable amount of experimentation is perfectly fine. They cited cases like Wood v. Underhill about making bricks, maybe you need to tweak proportions slightly, or mineral separation, where some preliminary tests might be needed for ores. But the key difference, the court said, was that Amgen's methods required much more than routine adjustment. It required significant trial and error discovery to find the unknown functional antibodies within that huge claimed genus. It crossed the line from reasonable experimentation into undue experimentation into invention itself.
What about Amgen's other arguments? Did the court address the idea that the Federal Circuit used the wrong standard or confused enablement with just the time it takes?
They did address those. The court clarified that, no, the Federal Circuit didn't improperly focus on just the cumulative time and effort. The issue wasn't just that it would take a long time to make millions of antibodies. It was the nature of the effort, the trial and error, the unpredictability involved in finding the unknown ones using Amgen's methods. And on the higher standard argument, the court basically said, look, there's only one enablement standard in the statute. But it's just logical that if you claim something vastly broader, like a whole genus defined by function, you naturally need to provide more enabling disclosure to meet that same standard compared to claiming one specific thing. It's about matching the teaching to the scope of the claim.
And it's worth emphasizing, again, this is unanimous, right? No dissenting opinions, no separate concurring thoughts.
That's right. Justice Gorsuch wrote for a unified court. Everyone was on the same page regarding how the enablement doctrine applied here. That unanimity sends a pretty strong signal about the court's view on this long-standing principle.
But what about that warning from Amgen? The idea that this ruling could stifle innovation, especially for these really complex, expensive biological drugs. Did the court just dismiss that?
They didn't dismiss the concern itself, but they were very clear about their role versus Congress's role. They acknowledged that finding the right balance, incentivizing breakthroughs versus ensuring public access to knowledge, is a really important policy question, a tough one. But they said adjusting that balance, maybe creating special rules for biotech or genus claims, that's a job for Congress. The court's job is to apply the law as written, the enablement requirement that's been there for centuries. It wasn't their place to rewrite the Patent Act based on policy arguments for one industry.
Okay, so pulling it all together, what's the real significance here? Why should people listening care about this particular case?
Well, legally, it's a very strong reaffirmation of the classic enablement standard, especially for these broad genus claims defined by function. That's super relevant today in fields like biotech, pharma, even software, where things move fast and initial discoveries might suggest huge possibilities. It draws a clearer line, perhaps, between what's considered reasonable experimentation to practice an invention, which is okay, and what's an impermissible hunting license requiring inventive effort, which is not okay for enablement. It tells inventors, you can't just stake a claim to a whole field of possibilities based on a few examples and a research plan.
So for innovators, maybe in a startup or even a big company, the message is pretty clear. You're going to claim a whole universe of things. Your patent needs to give a really solid, reliable guide for someone skilled in the field to actually make and use all, or at least substantially all, of those things. Not just your star examples, and not just by telling them to go experiment endlessly.
Exactly. It's about matching the breadth of your claim to the depth of your teaching. It reinforces that fundamental patent bargain. You get your limited monopoly, but only in exchange for genuinely enriching the public domain with knowledge that others can actually use once your time is up.
So if we had to boil it down to one single key takeaway from this whole deep dive.
I think it has to be that phrase the court kept coming back to, the more one claims, the more one must enable. It sounds simple, but it captures centuries of patent law and really underscores the responsibility that comes with seeking patent protection. You have to share what you know, clearly and fully, for the scope you're claiming.
Wow. We've gone from LDL cholesterol and antibody engineering all the way to 19th century telegraph patents and the core bargain of intellectual property. Quite a journey.
It really shows how these fundamental legal principles have to adapt, or rather, be applied consistently, even as science gets incredibly more complex. It forces inventors to think not just about what they discovered, but how effectively they can teach it.
It does make you think, though, with things like AI potentially designing millions of drug candidates or new materials emerging rapidly, how do we keep incentivizing those huge leaps? Especially when the full potential might take years, decades even, to explore after the initial breakthrough. Where is that sweet spot in the patent bargain today that encourages bold claims but doesn't block off entire fields based on maybe just a glimpse of the possibilities? That's something worth pondering. Well, that's all the time we have for this deep dive. Thanks so much for joining us.